The state government takes the position that the local government elections is a state matter under the 9th schedule of the Federal Constitution, and that the state legislature has jurisdiction to provide for the holding of local elections under the 9th schedule and Article 113, subsection 4 of the Federal Constitution. The state government has informed the Election Commission that the enactment will come into force in Penang by 31st January 2013. However, the state government has failed to obtain any commitment from the Election Commission to conduct elections to both councils in accordance with this enactment. In line with its commitment to restore the third vote, the state government has now instructed all lawyers to apply to the federal court for leave to seek declarations that Section 15 of the Local Government Act 1976, a federal law enacted by Parliament, which purported to abolish local government elections throughout Malaysia, is invalid or inoperative in Penang, and that the 2012 enactment here, passed by the Penang State Assembly, consented by the Governor and gazetted by the state government, validly provides for the Election Commission to conduct local government elections in Penang. The Penang State Government will, together with former Aliran President Mr. Ramakrishnan, be the two plaintiffs in this historic suit against the federal government and the Elections Commission at the federal court. Mr. Ramakrishnan has long cherished a dream to vote his own local councils.
There are provisions in the federal constitution which provide that if there is a challenge on the type of laws that are to be applicable. So in this case, this is really a dispute between whether a Penang enactment should govern local government elections, or the federal law by Parliament should govern local government elections. So it's a clash between state law and federal law. And according to the federal constitution, when there is such a clash, a dispute, it has to go to the federal court, and you bypass the High Court and the Court of Appeal. And not just the federal court, you have to get leave first. So when we file the papers within the next 2 weeks, after we file, we have to get leave of a single judge of the federal court.
Obviously, the Indonesian confrontation was not a problem when it came to the parliament and state elections. Then why was it a problem when it came to the local government elections? It was simply because the alliance was losing the choice urban councils. These were beyond their grasp. First, they lost the Penang City Council in 1958, then the Melaka Municipal Council in 1961, followed by the Seremban, Kluang and Bentong Municipal Councils in 1963, which came under the control of the Socialist Front. The PPP had also taken a firm grip on Ipoh in 1961. The alliance realized that the opposition was better able to win control of local councils than the state or parliamentary constituencies, and therefore were certainly not keen to allow them free play on these platforms. Thus, the Indonesian confrontation became a convenient excuse, however unjustified. But when the confrontation ended in August 1966, 18 months after the suspension was not lifted, in spite of a solemn pledge given by the Prime Minister in Parliament. It was the greed for power that denied the people their democratic right to elect their local leaders. The suspension had nothing to do with the great concern for the nation or the interests of the people. It was solely meant to preserve selfish interests to control and dominate the people. The federal government cannot and should not fall back on a legislation that has no legal standing to perpetuate an injustice that has been trying for a remedy for more than 4 decades.